Hi there, my name is Nicole Oden, and I am so excited to chat with you today about uncomplicating legal for your online business. So before I get started, who am I? I am married to my high school sweetheart. We have an almost 6-year-old little girl. I am a licensed attorney in the state of California, and I am also a small business owner. My mission really is to make legal accessible and affordable for other small online business owners. I think this is such an important piece of being a business owner. It's such an important investment for your business. And I assist online business owners in two capacities. First, I have my own online business. I offer legal templates for other online business owners who aren't ready to work with an attorney one-on-one, but know that they need to get some basic legal protections in place. You can head to NicoleOden.com to check out the legal shop with all of the templates listed. I also have a mini course. It's called Legal Basics for a Legit Online Business. And it is basically a legal guide, a 101 intro course to all of the legal topics that you need to know as an online business owner. And I have my own virtual law firm, Nicole Oden Law PC. So I practice family law. I've practiced family law for almost 10 years now, but I also work with online businesses, and it's such a fun part of my practice. I help online business owners, small business owners draft custom contracts and policies. I help with legal strategy sessions, and I also do federal trademark registration. So every way that you can protect your business, your income, and your brand as an online business owner. I'm very passionate about working with other online business owners. I think it's such a fun niche to work in. And you can check out my law firm at NicoleOdenLaw.com. So we're going to cover a lot of ground. I definitely want to make sure that you have the handout handy as we walk through these topics we're going to cover. Make sure you take some notes. I will share my email address at the end of the presentation. If you have some questions come up, you can feel free to reach out. We are going to cover, like I said, a lot of ground. So we're going to chat about Contracts 101, what a contract is and some key provisions to include. We're going to cover website policies because as an online business, it's so essential that you have these in place, from your privacy policy to your terms and conditions to your terms of use. We're also going to chat about copyright and trademark protections. And then I'm going to give you 7 key questions to ask an attorney before hiring them. So once you are ready to work with an attorney one-on-one for your business, these are kind of the key questions and concepts that you want to cover to make sure that it's going to be a good working relationship. So before we get started, I have to give my standard disclaimer. Everything I'm going to chat about today is legal education and information. It's not business, financial, or legal advice. It doesn't form an attorney-client relationship between us. And you definitely want to take the time to consult with an attorney in your area to cover your specific business needs. So let's jump in. Contracts 101. So what is a contract? At its basic definition, a contract really is a set of promises. So a person is promising to do something in exchange for something from the other person. Contracts can be oral or in writing, and both are legally enforceable. But oral contracts are a huge headache when it comes to proving that there was a meeting of the minds. There is a lot of he said, she said. And that is exactly why you're going to learn as we chat, written contracts are such a key component of your business, especially since, to complicate matters, every state has its own laws about what contracts have to be in writing. So in my opinion, all of your contracts in your business should be in writing. And that is the first blank on the handout that you have. Again, all of the contracts in your business should really be in writing. You don't want to be doing handshake deals. Because they really do help establish expectations and boundaries. The example that I like to give clients that I work with is Cindy Eckert. So she essentially worked to help develop the female version of Viagra. She built this massive behemoth company and ended up selling it for $1 billion. And part of the contract in that sale, part of a provision in that sale of the contract was that certain key employees were going to come along. There were going to be certain milestones that they were going to hit, and none of that happened. So she ended up being able to go in and have the sale set aside because of her written contract, and she actually recouped that $1 billion. She kept the $1 billion. And I like to give that example, not because obviously everybody has $1 billion business, But if a contract can protect a business owner to that extent, think of what it can do for you as an online business owner, as a small business owner. And I think that you definitely want to make sure you have a client agreement in place if you are a service provider. And so we're going to kind of walk through some of the 5 key provisions to include in your service provider client agreements, especially in the online space, coaches, VAs, OBMs. It's such a common misconception that you can simply kind of just send over an invoice and away you go. There's definitely some particulars that you want to make sure you lock down in writing. So we're going to cover those key provisions. The first being a scope of services provision. So you want to make sure that you are clearly articulating the services that you are agreeing to provide. So you want to make sure that you are providing things like how many rounds of revisions you might be offering if you're creating, social media content or blogs or whatever it may be. You want to be very detailed in the method by which you're going to be delivering services. Are you guys working from a Google Doc? Are you going to be providing PDFs? I mean, you want to be, again, very focused on that minutia as much as you can. Be as detailed as possible. I can't stress that enough. Provision 2 is your payment schedule. And this is one, obviously, as a business owner that we find very important because we want to make sure that we are getting paid, right? We're doing the work. And so we want to ensure that there is money in the bank account to reflect that. So whether you are expecting full payment upfront, if you're accepting installment payments, you want to be very, very clear how that payment is going to proceed. You also want to make sure that you're addressing things like late payments, if you accept installment payments, and what your refund policy is. And this means even if your policy is I don't offer refunds, you want to be very, very clear in the contract about the fact that you don't offer refunds. Now, I have a lot of business owners that will reach out and have a situation come up and they end up doing a cost benefit analysis where even if the contract provides that they don't provide refunds, they decide it makes the most sense to potentially issue a partial or full refund just to maybe stop things from going towards litigation or whatever it may be. That is a cost benefit decision you as a business owner have to make, but having that kind of strong language in your contract that gives you the flexibility as a business owner to decide if you want to, maybe be a little bit more flexible on your restrictions, that's fine. But you wouldn't have that opportunity if you don't have that in writing to begin with. So just something to keep in mind. The third provision that is very, very key, especially as a service provider, if you are providing content for other business owners, you want to make sure you're clearly addressing who the intellectual property rights vest in. And we're going to chat about trademark and copyright a little later on. But you want to make sure that you are either transferring the rights once they've paid in full. Are you retaining some rights to be able to use things in your marketing? I mean, this is language that you definitely want to look to because as a service provider, you are probably creating a plethora of deliverables from worksheets to photographs to files, PDFs, whatever it may be. You really want to make sure you're addressing who owns the rights to those materials. So this intellectual property provision, it protects your business's proprietary materials, and it really alerts your clients to that protection as well and lets them know kind of how things are going to go down in terms of the materials that you're offering. Another thing to keep in mind is that this intellectual property protection provision, if you're someone like a coach, or even if you're a service provider and you provide maybe samples to your clients, it really lays out what they can and can't do with those things that you're providing. If you're a coach, as an example, you don't want your clients to then turn around and share all of your proprietary materials with their friends so that they're essentially getting that benefit of the relationship without paying you. So having this provision in your contract is kind of one of those things that gives you the heads up. It gives your clients the heads up about the fact that they can kind of just run off with your proprietary materials. So it's definitely important to include this provision in your contract. Another important provision deals with independent contractor status. So you want to make sure in your contract that you are indicating you are not an employee, that you are providing services as an independent contractor. And something else to consider is whether or not you're going to include some sort of non-exclusivity provision in your contract. Are you able to work with clients in a similar industry? And vice versa. Are they able to work with a service provider like you in a similar industry and vice versa? Sometimes people are more lenient. Sometimes they have maybe very proprietary things that they're having their independent contractors work on, so they may not be so comfortable. It's something that you want to take as a contract by contract kind of weigh and discuss with your potential clients. But, as an online business owner, you are essentially a business in and of yourself, unless you are working more along the freelancer kind of avenue, in which case you definitely want to make sure that you are paying attention to the independent contractor laws in your state, because they differ. And I will tell you that states are starting to kind of amend laws to make it so that most people are viewed as employees, and there's some kind of significant burdens to overcome to show that you really are an independent contractor. I'm licensed in California. We have that uphill battle here. I know there's other states such as like Massachusetts that have very similar kind of independent contractor laws. So it's something you definitely want to take into account as you're drafting your contract, as you're considering kind of how you're going to proceed with providing services. And fifth is the dispute resolution provision. This is a very, very key, often overlooked provision in contracts. So this basically says what states' laws are going to govern an agreement's interpretation, and what states' courts are actually going to have jurisdiction over the dispute. So are you going to be in courts? Perhaps is an arbitration provision, you're going to arbitrate. I cannot tell you how many contracts leave this out. And then we're kind of just struggling to figure out how to interpret things. So you definitely want to include this provision, especially because if you have an issue come up with a client and you're having to chase them down, let's say they failed to pay, they breached, whatever it may be, typically lawsuits are filed in the jurisdiction of the wrongdoer. So you definitely don't want to end up having to travel to Timbuktu and hire counsel in Timbuktu to help you kind of chase down your client. So if you have the dispute resolution provision in your contract that says the agreement is going to be interpreted under California law, and if any issues come up, the state courts in, County of Los Angeles are going to dictate kind of how things proceed. Definitely something to include in your contract. I have a lot of service providers kind of ask about working with people outside of the United States. Enforcing a contract in a jurisdiction that is completely different and international is an uphill battle and a pain in the butt and expensive. You're going to have to not only have local counsel, but counsel in the jurisdiction. So again, just another reason to really pay attention to the dispute resolution provisions, not only in your contracts, but also the contracts that you are signing with other service providers that you're working with, or whatever it may be. It's essential really in the online business world. If you think the fact that we are a global economy at this point and we are just kind of making our world smaller, it's something that we're all going to come across kind of on a more frequent basis as the online business space expands. So something definitely to be paying attention to. So one tip that I like to give business owners is that you are going to execute your contract in accordance with your business entity. So if you're a sole proprietor, you are going to execute your contract as yourself. And that is because as a sole proprietor, you and your business are essentially the same person. Now, if you've taken the step to form a corporation or an LLC, then you are going to actually execute the contract on behalf of your company. So if you are CEO of your corporation, you're going to execute it, Wendy Zimmerman, CEO, XYZ Incorporated. That is because you are your business, and that's how you are entering into that contractual relationship. So it's definitely something that you want to pay attention to. So I know we ran through that a lot, but that was 5 provisions you want to be paying attention to in your contracts, your service provider contracts especially. And now we're going to chat a little bit about website policies. So the first one that we're going to cover, because it is legally required, and so that's something that you want to be putting in the second blank on your worksheet, is the privacy policy. So in 2004, California was actually the first state in the United States to make it a legal requirement for your website to have a privacy policy if you were collecting what's called personally identifiable information from a Californian resident. We actually had updated updated legislation that went into effect in January of 2020 called the California Consumer Privacy Act that added even further requirements if you are doing business in the online space. And in May of 2018, the European Union enacted the General Data Protection Regulation, or GDPR, which if you are in the online space, I'm sure that you've heard this term thrown around quite a few times. And it made it a requirement to have a privacy policy if you process personal information from even one EU or UK resident, no matter where you are based. So again, going back to that concept of being a global economy and the reach of the interwebs, you never really know where your website users are coming from. So under California law, under EU law, under many other states that are now enacting their own privacy policy legislation, you have to have a privacy policy on your website. And yes, it is if you are collecting personal information, but I will tell you that in today's day and age, you are collecting personally identifiable information from your website users. And we're going to chat about that in a minute. Personal information it's comprehensive. So it's email addresses, first and last name, telephone number, physical address, birthday, height, weight. Really, it's anything relating to a physical, physiological, genetic, mental, economic, cultural, or social identity of a person visiting your website. As I said, it's super comprehensive. And this does include IP addresses. So all of the tracking software and the cookies that you have on your website for Google Analytics, the Facebook pixel, the Pinterest tag, all of this stuff falls under having a website user's consent under GDPR, which is required to process personal information. So if you think about your own website, I think the most common example is an opt-in. You probably have some sort of freebie or discount coupon or whatever you may refer to it as, and you're collecting somebody's email address, their name, in exchange for that freebie. That's personally identifiable information, which means you need a privacy policy. So under the California legislation, you have to have your privacy policy clearly and conspicuously posted. And this means you literally have to put the text on your website's page so that viewers can see it and agree to it. Or the more common practice is to basically put a hypertext link in the footer of your website, which is also called a browser app in internet law, where we've all seen them. You visit the websites and at the very bottom, there's words and you can click on them and it takes you to a new page, and that's privacy policy and it takes you there. That is, I wanna say 99.9% of what most website users do, just because it's not aesthetically pleasing to have a huge privacy policy on your website's page, considering the length of policies now because of all of the information that you have to include. I say it's actually a better practice to not include it just as a hyperlink on your website and call it a day, but you really need to be having your website users affirmatively agree to your privacy policy before they provide you with your personal information. So a few minutes ago, I said that under GDPR, your website users have to provide that affirmative consent, especially to things like cookies, which is why you see all these cookie bars popping up on everybody's websites. This really does, I think, apply to all businesses across the interwebs. I think it's the best practice. It really does put the power back in your consumers' hands. And it's a great way for you to show as a business owner that you are only collecting information that your website users are agreeing to provide you with. So I think it's a better practice to actually use a click wrap method when you are collecting that information. And so this really means that you have a spot on your website form or wherever it may be, where the website user has to say, I've read and I agree to the privacy policy, and they either check a box, they click a button that says I agree, whatever it may be, they're taking some sort of affirmative action. And I'm going to show you an example. So this is an opt-in I have on my legal templates website, and it is your email marketing legal? 9 things that you should know. And if you provide your name and your email address, you receive the freebie. I actually have my website users agree to both my privacy policy and my terms and conditions before they can even submit to receive the freebie. So kind of just reaffirming, GDPR actually requires affirmative consent from your website viewers to process their personal information. And this is kind of twofold. So it has to be freely given, specific, informed, and unambiguous, which is a lot of language to unpack. And they have to take some sort of action that says, yes, you can process my personal information. So I can't think of a better way to say it was freely given. It was very specific, it's unambiguous, and they're taking action than having that checkbox or a button or something that they're actually physically doing to provide you with the information in exchange for you collecting the email address or the name or phone number or whatever it may be for your particular lead page or opt-in or whatever it is that you may call it. So this is why I say it's definitely, I think, a better practice to enact this for your online business. And GDPR refers a lot to processing personal information. It really means basically doing anything with personal information because it's collecting, recording, retrieving, storing, disclosing, or using. And if we take that email example that I gave, you're collecting it when they submit it through your website, you're recording it through your website, you're retrieving it when you send, your email campaigns vis-a-vis your email service providers like ConvertKit or MailChimp or whatever it may be. You're storing it in your email service provider. I don't know if you're disclosing it. You may be, if you have independent contractors you work with, they obviously have access to potentially your client list. So that could be considered disclosure. And you're using it because you're probably using that email address for email market campaigns to send orders to whatever it may be. So as I said, processing is all encompassing. If you have a website, no matter where you're located at this point, you really need to be having that privacy policy in place. And you really want to make sure that you're having your website users agree to that privacy policy. And this is because there are potential fines. And I know a lot of people will say, I'm a small business, doesn't matter. I'm going to explain why it matters. So under that initial California legislation from 2004, it was $2,500 per violation. So that means every time somebody visits your website and you are considered in violation, $2,500, which can add up very quickly. Then we had the January 2020 legislation that came along, and it ranges between $2,500 to $7,500, again, per violation, depending on if you had kind of a intention to not comply. But with this legislation, a private right of action was added so that if you have a data breach, meaning let's say somebody is able to hack into your website and steal your customers' confidential, private, personal information, they can then hold you personally liable. So you can not only be receiving that fine from the Attorney General, but you could also be subject to a personal lawsuit from a potential client or customer. That's a big deal. And this kind of goes hand in hand with the GDPR legislation from 2018. Fines under that legislation are 20 million euro or 4% of the business's worldwide revenue of the prior year, whichever is higher, which is a lot of money, guys. And again, consumers have a right of private action if there is a breach, which is a big deal. So it's, definitely something that you want to be paying attention to. It sounds overwhelming, and I know this is a lot to cover in a very short class, but if you take nothing else away from this, know that you have to have a privacy policy, period, end of story. Terms and conditions. So this is the second website policy that we're going to chat about. And essentially, your terms and conditions are the ground rules for your website. So they lay out what your website users can and can't do in terms of your content. They include things like limitations of liability and disclaimers. Let's say you are a health coach. This is the spot where you are going to want to put language that basically your health information is that. It's information and education, and you are not going to be held personally liable if somebody comes to the website, reads an article, and decides to stop taking medications, to change their diet, and they are basically impacted because of that. You want to make sure that you're including language about how and where disputes will be handled. You want to include things like third-party and affiliate links and how those are handled. Most of us on our websites these days, may share products or programs from other websites. You want to make sure that you're clearly saying you are not going to be held liable for if they have a bad experience on another website after following a link from your website. They have their own, terms and conditions versus you as a business. So again, these are essentially the rules of the road These are not legally required. So this is different than privacy policies, where those are affirmatively required as a website owner, as a business owner. But they're a very good gold star practice to have in place, because quite honestly, this is the first place a court is going to look if you have a dispute with a client or customer in the online space. They're going to look to see if you have any sort of disclaimers or indemnification language. We're going to chat about terms of use in a minute, but if you sell products, that's also something that you want to have in place. I am a firm believer of having your website users actually affirmatively agree to your terms and conditions, just like they did with your privacy policy. And you saw that on the example I shared on my website. I do have them agree to the terms and conditions because it includes language about what they can do with the freebies. And it is very clear that I have my intellectual property rights protected, and I intend to protect those rights going forward. You will see a lot of times people will have disclaimers separate from their terms and conditions. I think that if you're having your website users affirmatively agree to your terms and conditions, like your privacy policy, incorporating your disclaimers into your terms and conditions is a better practice. You have a stronger argument in terms of saying that an enforceable contract was created versus just slapping disclaimers up. That being said, I think it's a smart practice to have them in your terms and conditions, have them agree, and then also have them on the website. I think it just makes sense to have them in multiple places. So take that as you may. I'm an attorney, obviously, so protect, protect, protect is kind of my motto. But I do think having that affirmative agreement to your terms and conditions is a very smart idea. Okay, so whereas terms and conditions are the rules of the road for your website and its content, terms of use are the rules of the road for your digital products. So your downloadable products like templates and photographs, e-courses, memberships, you definitely want to have terms of use in place, because these lay out how your purchasers can and can't use the product that they're purchasing. This will include things like your refund policy, your payment policy, again, those intellectual property protections. And so when somebody is processing through to purchase your digital product, having them agree to both your privacy policy and terms of use in that checkout process before they even enter their payment information, before they can even process further on your website, I think is one of the best things that you can do as an online business owner. And that is really because it's creating that enforceable contract. That's an overview of website policies. I know, again, it's a lot to cover. I have a limited amount of time with all that I'm jamming in, but you can head to NicoleCheriOden.com. I have blog posts there that dive much more into what should be in your privacy policy, what should be in terms and conditions and terms of use. And you can find, again, in that legal shop, if you're not ready to work with an attorney one-on-one, I do have templates for those policies. So just something to be aware of. Okay, so we're going to transition a little bit from contracts and provisions and things of that nature to chat about intellectual property protection. So intellectual property really means that you're protecting the rights of the original works that you are creating. And we are going to cover, as I said, copyright and trademark. So we are going to start with copyright. And I think this is an important distinction as an online business owner to know, and as a small business owner, because we are creating a lot of intellectual property as we kind of are creating content and visuals and things of that nature. So just understanding the distinction and knowing that these rights are something that you need to be paying attention to, I think is very important. So copyright is legal protection for original works of authorship that are expressed in a tangible medium. So it basically applies to everything from that point of creation, your blog posts, your photographs, your website copy, anything that you are creating that is, again, an original work. It doesn't count if you are copying verbatim from a website or taking somebody else's photograph essentially from their website and using it as your own. It's something that you're creating and it's original. This is not ideas. So you have to physically express your idea. You have to draft the blog post. You have to take the photograph. You have to paint the picture, whatever it may be, for those copyright protections to attach. and it's fact specific in the United States. But there are 6 specific exclusive rights that you get to your copyright rights under the Copyright Act of 1976. So we're going to chat about these briefly, and I'll give some examples just so you have kind of an idea. So the first is the right to make reproductions or copies of the copyrighted work. So you can, produce multiple copies of the same blog post. You can copy the photograph, whatever it may be. The second is to prepare derivative works based on the copyrighted work. So you can take the photograph and, maybe turn it into a song if there's specific things in the photograph that you're singing about. You can take the blog post, turn that into social media content. However it may be, it's basically something that is derived from that first initial work. A good example is sometimes books will become movies, obviously. The third is the right to sell or transfer the copyrighted work. So you as the copyright holder have the ability to license the copyrights to the photograph, the social media content, whatever it may be, you have the ability to do that. Fourth is the right to publicly perform the work. I don't think you need an example of that. Fifth is the right to publicly display the copyrighted work. So be this in shop windows or on your website, however it may be, you are publicly displaying it. And the sixth is the right to publicly perform the work by audio transmission. So this one applies more to sound recordings in terms of being able to broadcast it on radio as example. So in the United States, copyright rights are an opt-out system. So from that moment of creation, those copyright rights attach and you have them. There's no magic language, there's no formula, there's, nothing. It automatically attaches. There's no formalities. Previously, under old copyright laws, you were actually required to include a copyright notice with everything that you claimed copyright to, registered copyright rights to, but it's not required anymore. But it's still why you see everywhere in most people's work, they have the C in a circle, the year of creation, and then your personal or company name, depending on if you're creating it as a sole proprietor, as an entity. It's still a recommended practice because you're putting people on notice that it's your protectable copyrighted work. And that's why you see it everywhere. Just because copyright rights are automatic, it's still a good idea if it's something that you plan to have in place for a long time and continue using, let's say like a course, your website, whatever it may be, to formally register it. And that really does help protect you against copycats. Registration is required if you actually want to enforce your rights and get things like statutory attorney's fees and damages. And by statutory, that means legally required, essentially. So if you register your copyright rights, you have the ability to take the infringer to federal court. And if you win, then they have to pay you damages and fees. So it's something to pay attention to, because a lot of the time, if a business gets a cease and desist letter and whatever the business that is sending the letter says is copyrighted and it's not registered, it's probably going to end up being a bigger headache versus if you have the registered copyright rights and you send the cease and desist, you're going to have, it's going to weigh in your favor. Essentially, it's going to be a much easier process and you're going to be able to enforce those rights. So copyright registration lasts for the life of the author plus 70 years. And once those copyright rights expire, then the work enters the public domain. Public domain essentially means the item is not protected. There's no protection from intellectual property laws. The item is free for anybody to use without having to ask permission. So just a reminder, copyright rights attach automatically from the moment that you create something, but you definitely want to be chatting with an attorney about getting the copyright registration if you intend to really protect it and enforce those rights down the line against potential infringers. So trademark rights. So a trademark is protection for a word, a phrase, a logo, a graphic, a symbol, something that ties to your brand. Trademark is protection so that consumers are not confused by two similar looking brands. It's brand protection. So if you think Coke and Pepsi, you know they're distinct. You can apply for federal trademark registration for things like your business name, your service or product name, podcast name, blog name, tagline, logo. You can even apply for trademarks for things like sound recordings and scents. The Play-Doh scent is actually a trademarked item. It's federally registered, so just something to be aware of. Similar to copyright rights, most states provide common law or statutory trademark protection. So that means from the moment that you start using the trademark, you have the rights to that trademark, even if you haven't actually formally registered it. But again, registering your trademark, either federally or state level, does provide distinct advantages to make it easier to protect your mark. I am a huge proponent of federal trademark registration versus state registration, because with a state registration, you're limited to protections within that state. And especially in the online space, most businesses are building a brand, meaning that they're intending to sell, US wide, if not globally. And so I think the protections of federal trademark registration are a better idea. It's a case-by-case scenario, and you definitely want to kind of determine if your trademark is limited to your state. But in the online business space, that's typically a no. So just something to be aware of. So why would you move forward with a federal trademark registration? So you have the ability to enforce your exclusive trademark rights in the United States, which is a big thing, similar to the copyright registration, where you can go in for the statutory damages and fees. It applies also for trademarks. You have the ability to use the R in a circle symbol to let infringers know that you actually have a federally registered trademark. You will see a lot of times in the online space, people use the small TM or the small SM. TM stands for trademark, SM stands for service mark. The difference is that the TM for trademark applies to goods versus the SM for service mark applies to services. That doesn't mean that there is an actual registered mark. Those are just basically to put potential infringers on notice that you claim that you have intellectual property rights to that product or service. Again, it doesn't mean it's actually registered. So with federal trademark registration, you have the ability to sue for infringement in federal court. You can recover the attorney's fees and damages. You're actually able to file that federal trademark registration with the US Customs Office to prevent the importation of foreign goods that could potentially infringe on your mark if you have a good. You are also easier able to register your mark in foreign countries if your brand is kind of a more global brand. It makes the process much more streamlined. And a big thing is it really is an asset for your company. And this goes both for copyright registration and federal trademark registration or state registration if you go that route. Building a solid IP portfolio for your business, it adds to your legacy, it adds to your potential business value. And it's just really cool to be able to hang your registration certificate, in your place of business, in your office, wherever it may be, and know that that is your baby. I mean, that's your work of your mind, and it is something that will only build value for your company. So I say that it is a smart business move to actually do a trademark name search prior to deciding on a product, a business, a service name, whatever it may be. So this is the third blank on the worksheet is before registering your trademark or launching your product or service, whatever it may be, you really do want to perform that clearance search. You want to make sure that nobody else is using the mark. You don't want to be on the receiving end of a cease and desist letter. So this is one of the most important steps that you can take as an online business, kind of before tying yourself and investing to a brand, doing that initial search yourself, and then working with a knowledgeable attorney to make sure that there really aren't any issues, I think is one of the best things that you can do for your brand. So you can start by searching your Secretary of State's website for your state, looking for corporations and trade names that are similar. Look on social media sites, look on Instagram, look on Facebook, look on LinkedIn, see if there's anything similar. Do a Google search. You can actually go to the USPTO's website yourself and search around in the TESS website, which is essentially the trademark electronic search system. There are nuanced ways to do searches, but you can at least do the initial knockout search to make sure that there's not an exact name match. It really does hinge on a likelihood of confusion, so that's something to keep in mind. It doesn't have to be an exact match for there potentially to be an issue and have the USPTO decline the registration. But again, this is kind of the initial groundwork before you move on to working with an attorney to find the specifics of the search. So we chatted about what a contract is, some basic key provisions to include. We chatted about website policies you definitely want to make sure you have in place, copyright and trademark. And now I'm going to give you 7 key questions to ask before hiring an attorney. This is something that I get asked a lot, is how do I know if it's going to be a good working relationship with me and the attorney? And this is why I kind of developed this list. So the first question would be, do you have experience working with online businesses? Not every small business attorney actually has experience with online businesses. There are a lot of nuances. It's a very new area of law, although the online business space has been around for a while. The law is a slow-moving turtle, so it's just something to be aware of. And you can also kind of qualify this question by asking if they have any business experience outside of maybe running their own law firm. An attorney that has experience running a business oftentimes has kind of those valuable insights that they may not have if they haven't been a business owner themselves. Number 2, what types of clients do you typically work with? Everybody's business is different, and every small business attorney, every online business attorney has kind of their different niche area of expertise, their preferred clients. And so are they working with small businesses? Are they working with large corporations? Are they working with startups? I mean, it's just something for you to kind of take in mind and consider. You want to ask how they bill. Are they hourly? Do they offer flat fee? Do they require a retainer? It's all kind of something to lay out. Some attorneys will have different fee structures depending on what you're doing. But if you're just starting out, maybe you have a smaller budget versus getting somebody that's on retainer. So just again, something to consider. The fourth question, how do you communicate with clients? So do they prefer email? Do they prefer telephone calls? Are you somebody who wants to physically be in an office for a meeting? You know, all attorneys have different preferences. All business owners have different preferences. So it's something that you definitely want to weigh in the decision making. Who will be handling my matter is one of the key questions. If you're working with a sole attorney or a smaller firm attorney, are they going to be working with you one-on-one? Or is it maybe a larger firm to where they're going to kind of pass your case along to a paralegal or an associate and maybe just do some high-level oversight? You know, is there a specific chain of command? Who are you going to communicate with? These are all questions that you definitely want to ask. Do you make referrals when necessary? So there are some attorneys who will try and do everything themselves and keep things in-house, and it could be to your detriment because it might be an area of law that they do not have exposure or experience in. You want to make sure that they are referring to attorneys in a specific area of expertise. The biggest example I give is tax law. So business attorneys are typically not tax law experts. They're just not. Tax law is a very nuanced area of practice, and you know, most attorneys are tax attorneys, and that's what they do. So if you have a tax question come up, you want to make sure that they're reaching out to a colleague or referring you to a colleague to ask the questions so that you are making informed decisions about your particular business. And I think one of the most important, if not the most important, is do you connect with the person? This is something that you feel confident and comfortable with. Do you trust kind of that they're looking out for your best interests, that they're on the up and up in terms of their knowledge about your particular business? You just want to make sure it's somebody that you're comfortable with. So, you know, sometimes that's a gut reaction. Sometimes it takes a little bit of interaction, a couple of questions, but it's definitely something to weigh in as you're considering whether or not to hire that specific attorney for your business. So we covered a lot of ground. As I said at the beginning, if you have questions that come up after watching and reviewing the worksheet, you can feel free to email me at nicole@nicolesheodenlaw.com. As a reminder, I cannot give specific legal advice. I can kind of provide general resources and point you in the right direction, and I'm more than happy to do that. So please feel free to reach out. And if you are interested in snagging a legal template for your online business because you know that you are just not ready to work with an attorney one-on-one, you can head to nicolesheoden.com, which is my legal templates website, and check out the templates and the template bundles that are listed for sale there. I hope that you at least walk away with the knowledge of the fact that you need written contracts, that you need those website policies, especially your privacy policy, and that you definitely want to be cognizant of copyright trademark protections as you're working through your business. And I hope that you have a wonderful rest of your day.